Hello, my name is Daphne Hamilton. I'm an attorney at McCarthy Law, and for today's Tip Tuesday, I'm going to talk to you a little bit about the duration of powers of attorney. So ordinarily for most estate planning documents, including both a financial and a healthcare power of attorney, there is not a duration, which means that if there is no end date on the document, ideally and hopefully your document is going to be able to be utilized for your lifetime. But with powers of attorney, first things first, they're only helpful during your lifetime. So as soon as that person has passed away, the power of attorney can no longer be using that document to act on their behalf. That's when it transitions to part of their estate. But we have run into issues with documents that even if there is no duration, that the document is legally stating that it's valid for the remainder of that person's lifetime, we have run into some banks and institutions giving more discretion with stating that if documents like powers of attorney, if they are over 10 years old, they will not accept them. So although that isn't the most enjoyable thing to hear, because most people want to be doing these documents and not having to worry about updating them, we do suggest for our clients that they're taking a look at their documents and the age of them every couple years. So for you to not be running into a situation that, say, you're acting as mom's power of attorney, it's an emergency situation, she no longer has capacity, and you need to start signing checks for her. If the bank is not going to be accepting of that power of attorney because it's over 10 years old, you're really going to end up in a bind. Because now, if mom does have a lack of capacity, she's not going to be able to sign a new power of attorney to make it an earlier date. So that's why it's definitely recommended to be taking a look at those documents every couple years so that you're not running into that issue.